Hello, my name is Ian Edwards. It's a real privilege to make this presentation to you on the subject of prisoners of war status in international armed conflict, and I thank the IBA for inviting me to do so. I'm a criminal defense lawyer from London, in the UK. I've been practicing before international criminal tribunals since 2009. I currently appear before the International Criminal Court in The Hague, where I defend a client from Darfur, Sudan. I also represent a client from Rwanda before the International Residual Mechanism for Criminal Tribunals based in Arusha, Tanzania. In this presentation, I will provide a short introduction, firstly, to the Geneva Conventions in general, and to the Third Geneva Convention, which deals with prisoners of war in particular. Secondly, I'll move on and speak about some of the most important provisions of the Third Geneva Convention. That will take up the majority of this talk. Thirdly, I will discuss briefly articles of the Criminal Code of Ukraine that address prisoners of war. Finally, I will mention some important international criminal law jurisprudence about the issue of prisoners of war in international armed conflicts. The Geneva Conventions of 1949 are composed of 4 treaties and 3 additional protocols. They represent revisions to earlier Geneva Conventions, parts of which date back to 1864. The Third Geneva Convention was first adopted in 1929, but was replaced in 1949. Ukraine, as one of the Soviet Socialist republics, and Soviet Russia, signed the Third Geneva Convention on 12 December 1949. Ukraine ratified on 3rd August 1954, and Soviet Russia on 10th May 1954. The updated Geneva Conventions of 1949 were a response to the horrors of World War II. The underlying principle of all 4 conventions is respect for the life and dignity of the individual, even, or especially, in situations of armed conflict. The conventions recognize that persons that suffer during armed conflict must be aided, protected, and cared for. They must in all circumstances be treated humanely, without any adverse distinction founded on race, color, religion or faith, sex, birth, wealth, or any other similar criteria. The president of the International Committee of the Red Cross has described the Third Geneva Convention as being the most comprehensive instrument for the protection of prisoners of war in international law today. Its purpose is to ensure that all such prisoners are treated humanely and held in decent conditions, regardless of which side they belong to. The convention aims to protect the physical and mental integrity of prisoners of war and to ensure that the detaining authorities provide for their physical and psychological needs. Under its provisions, murder, torture, and any other form of inhumane or degrading treatment are prohibited. Prisoners of war must have access to food, healthcare, and hygiene facilities, and it is mandatory to identify detained persons and to enable them to maintain contacts with the outside world so that they do not go missing. So now I'll turn to explore some of the most important articles of the Third Geneva Convention and how they apply or should apply in practice. I'll refer to it simply as the Convention for the rest of this presentation. Now, you may be wondering why the title of this presentation is Prisoners of War Status in International Armed Conflict. Why specifically international armed conflict? The answer to that is that international rules relating to the treatment of combatants and of prisoners of war are very different as between persons captured in the course of an international armed conflict as opposed to a non-international armed conflict. Article 2 of the Convention states that the Convention shall apply to all cases of declared war or of any other armed conflict which may arise between 2 or more of the high contracting parties, even if the state of war is not recognized by one of them. The Convention shall also apply to all cases of partial or total occupation of the territory of a high contracting party, even if the said occupation meets with no armed resistance. Now, in the case of the ongoing war between Russia and Ukraine, there is no doubt that this is an international armed conflict, and so the Convention will apply fully. But for the sake of completeness, let me cite Common Article 3 of the Convention, called Common Article 3 because it is found in all 4 of the Geneva Treaties. It deals with what shall happen in the case of a non-international armed conflict. And I quote, "Persons taking no active part in the hostilities, including members of armed forces who have laid down their arms and those placed hors de combat by sickness, wounds, detention, or any other cause, shall in all circumstances be treated humanely, without any adverse distinction founded on race, color, religion or faith, sex, birth or wealth, or any similar criteria. Such persons shall not be subjected to violence, in particular murder, mutilation, cruel treatment and torture, or to taking of hostages, or outrages upon personal dignity, in particular humiliating and degrading treatment, or the passing of sentences and the carrying out of executions without a trial, respecting normal, minimal judicial guarantees." So that's the article that deals with persons in a non-international armed conflict. The protection for prisoners of war in international armed conflict are much, much wider. The reason for this distinction between armed conflicts of an international and non-international character have been the subject of a great deal of legal debate over many years, and this is far beyond the scope of this presentation, I'm afraid, but I thought it would be worth bringing the matter to your attention. Combatants in an international armed conflict benefit from what is sometimes called combatant privilege. Combatants, after all, have the right to take part in hostilities. Combatants, after all, have the right to take part in hostilities. They have a right to attack the adversary and to weaken the enemy military forces. The other side of that coin is that combatants can lawfully be the object of attack and may be targeted by the military forces of the enemy. There is nothing necessarily inherently unlawful about an international armed conflict. And so a combatant who kills or assaults and injures an enemy combatant in the course of an international armed conflict is not liable in international law to be put on trial for murder or assault, and should not be liable in national law either to be put on trial. If captured, the combatant should not be punished, and so their detention as a prisoner of war is not punitive. Prisoners of war are detained for the simple purpose of preventing them from returning to the battlefield. The one exception to this is if a combatant violated international humanitarian law, i.e., committed war crimes. Then he can be prosecuted and punished. Article 4 defines who can be described as a prisoner of war and who therefore has protection under the Convention. In essence, Article 4 underscores that prisoners of war have not done anything wrong per se. Prisoners of war status must be conferred on the following categories of person. Firstly, members of the armed forces of a party to the conflict, as well as members of militia or volunteer corps forming part of such armed forces. Secondly, members of other militias and members of other volunteer corps, including those of organized resistance movements, belonging to a party to the conflict and operating in or outside their own territory, even if this territory is occupied, provided that such militias or volunteer corps or organized resistance movements fulfill the following 4 criteria. A, that of being commanded by a person responsible for his subordinates. B, that of having a fixed distinctive sign recognizable at a distance. C, that of carrying arms openly. And D, that of conducting their operations in accordance with the laws and customs of war. The third category of person comprises members of regular armed forces who profess allegiance to a government or an authority not recognized by the detaining power. 4, persons who accompany the armed forces without actually being members of the armed forces, such as civilian members of military aircraft crews, war correspondents, supply contractors, members of labor units, or of services responsible for the welfare of the armed forces. 5th, members of crews of the merchant marine and the crews of civil aircraft of the parties to the conflict. 6, inhabitants of a non-occupied territory who, on the approach of the enemy, spontaneously take up arms to resist the invading forces without having had time to form themselves into regular armed units, provided they carry arms openly and respect the laws and customs of war. In addition, persons belonging or having belonged to the armed forces of the occupied country, if the occupying power considers it necessary by reason of such allegiance to intern them, even though it has originally liberated them, while hostilities were going on outside the territory it occupies. In particular, where such persons have made an unsuccessful attempt to rejoin the armed forces to which they belong and which are engaged in combat, or where they fail to comply with a summons made to them with a view to internment. So, armed forces are all organized armed forces, groups and units, which are under a command responsible to that party for the conduct of its subordinates, even if that party is represented by a government or an authority not recognized by an adverse party, and subject to an internal disciplinary system which, among other things, shall enforce compliance with the rules of international law applicable in armed conflict. Special attention can be given here to the status of mercenaries and spies. Now, the lawfulness and legitimacy of the activities of mercenaries is not really covered by international humanitarian law. A mercenary can be defined according to the following 6 conditions. He or she is specially recruited locally or abroad in order to fight in an armed conflict. He or she takes a direct part in the hostilities. He or she is motivated to take part in the hostilities essentially by the desire for private gain, and usually is promised by or on behalf of a party to the conflict material compensation that is substantially in excess of that promised or paid to combatants of similar rank and function in the armed forces of that party. He or she is neither a national of a party to the conflict nor a resident of territory controlled by a party to the conflict. He or she is not a member of the armed forces of a party to the conflict. And sixthly and finally, he or she has not been sent by a state which is not a party to the conflict on official duty as a member of its armed forces. As you might imagine, a mercenary does not have the right to be treated as a combatant or a prisoner of war. As for spies, well, a spy is defined as a person when acting clandestinely or on false pretenses, obtains or endeavors to obtain information in the zone of operations of a belligerent with the intention of communicating that intelligence or information to the hostile party. A spy caught without wearing uniform will not have the right to prisoner of war status. But if a spy subsequently rejoins any force to which he or she belongs as a soldier, and is then later captured by the enemy, he or she must be treated as a prisoner of war and cannot be prosecuted for his previous acts of espionage. Article 5 of the Convention defines when the Convention starts to apply to a prisoner of war and when it ends. The Convention shall apply to the persons referred to above in Article 4, from the time they fall into the power of the enemy until their final release and repatriation. Importantly, Article 5 provides that should any doubt arise as to whether persons having committed a belligerent act and having fallen into the hands of the enemy belong to any of the categories in Article 4, such persons shall enjoy the protection of the Convention until such time as their status has been determined by a competent tribunal. Who is responsible for the treatment of prisoners of war? Well, Article 12 provides that prisoners of war are in the hands of the enemy power, but not of the individuals or military units who have physically captured them. It is the detaining power that is responsible for the treatment that is given to the prisoners. This necessarily implies the engaging of state responsibility, as well as individual criminal responsibility of persons who have the duty to exercise that responsibility. Prisoners of war may be transferred to another power if that other power is a party to the Convention, and only after the detaining power has satisfied itself of the willingness and ability of the transferee power to apply the Convention. If the transferee power fails to carry out the provisions of the Convention in any important respect, the original transferring power shall take effective measures to correct the situation, or shall request the return of the prisoners of war. Such requests must be complied with. I move now on to Articles 13 and 14, which set out really the key rights of prisoners of war. Prisoners of war must at all times be humanely treated. Any unlawful act or omission by the detaining power causing death or seriously endangering the health of a prisoner of war in its custody will be regarded as a serious breach of the Convention. In particular, prisoners of war may be subjected to physical mutilation, In particular, no prisoner of war may be subjected to physical mutilation or to medical or scientific experiments of any kind which are not justified by the medical treatment of the prisoner concerned and carried out in his interests. Prisoners of war must at all times be protected, particularly against acts of violence or intimidation and against insults and public curiosity. Measures of reprisal against prisoners of war are prohibited. Prisoners of war are entitled in all circumstances to respect for their persons and their honor. Women shall be treated with all the regard due to their sex and shall in all cases benefit by treatment as favorable as that granted to men. Article 25 makes it clear that in any camps in which provided for women. Similarly, Article 29 provides that women shall have access to separate toilet and washing facilities. The detaining power must respect the inherent human dignity of prisoners of war and their inviolable quality as human beings. This includes respect for their military honor. So, for example, prisoners of war must be permitted to wear badges of rank and nationality, as well as military decorations, and officers may not be compelled to work. We come back to the question of work in a few moments. Article 15 states that the power detaining prisoners of war shall be bound to provide free of charge for their maintenance and for the medical attention required by their state of health. And Article 16 underscores that prisoners of war shall be treated equally, in the sense that there must be no adverse distinction made based on race, nationality, religious belief, or political opinions, or any other distinction founded on similar criteria. Having said that, prisoners of war can expect to be treated differently based on their rank and sex, and subject to any privileged treatment which may be accorded to them by reason of their state of health, age, or professional qualifications. Article 17 sets out the rules relating to questioning of prisoners of war. Every prisoner of war is bound to give only his surname, first names and rank, date of birth, and army, regimental, personal, or serial number, or equivalent information. If the prisoner willfully infringes this rule, he may render himself liable to a restriction of the privileges accorded to his rank or status. But a prisoner who refuses can under no circumstances be physically or mentally tortured or subjected to any other form of coercion. They may not be threatened, insulted, or exposed to any unpleasant or disadvantageous treatment of any kind. All prisoners of war must be provided with an identity card. Prisoners of war must be allowed to retain their personal property, except of course for arms, military equipment, and military documents. And as was alluded to earlier, badges of rank and nationality, decorations, and articles having above all a personal or sentimental value may not be taken from prisoners of war. Money can only be removed from a prisoner of war on the order of an officer, and when money is removed, it must be properly registered and a receipt provided. Article 19 makes it clear that prisoners of war shall be evacuated as soon as possible after their capture to camps situated in an area far enough from the combat zone for them to be out of danger. Only those prisoners of war who, owing to wounds or sickness, would run greater risks by being evacuated than by remaining where they are, may be temporarily kept back in a danger zone. I said earlier that detention is not to be considered punitive. It is to prevent prisoners of war from returning to the battlefield. Necessarily, therefore, freedom of movement of prisoners is restricted, and that is allowed by the Convention. But prisoners of war must not be subjected to close confinement, and they must be detained on land. As a general rule, detention should not be in prisons. Article 22 provides that the detaining power shall assemble prisoners of war in camps according to their nationality, language, and customs, provided that such prisoners shall not be separated from prisoners of war belonging to the armed forces with which they were serving at the time of their capture, except with consent. Prisoners of war, of course, can never be used as human shields. Article 23 states that no prisoner of war may at any time be sent to or detained in areas where he or she may be exposed to the fire of the combat zone, nor may his or her presence be used to render certain points or areas immune from military operations. Prisoners of war shall have shelters against air bombardment and other hazards of war to the same extent as the local civilian population. Prisoners may enter such shelters as soon as possible after the giving of any alarm. Any other protective measures taken in favor of the population shall also apply to prisoners of war. To ensure against attack from the air, and whenever military considerations permit, prisoner of war camps shall be indicated in the daytime by the letters PW or PG, placed so as to be clearly visible from the air. An important principle of the Convention is the one according to which prisoners of war should, in general, be treated on the same terms as members of the armed forces of the detaining power. Therefore, in the context of evacuation, which I mentioned a moment ago, this shall always be effected humanely and in conditions similar to those for the forces of the detaining power in their changes of station. And the same goes for prisoners' quarters. Article 25 provides that prisoners of war shall live under conditions as favorable as those for the forces of the detaining power who are billeted in the same area. These conditions shall make allowances for the habits and customs of the prisoners and shall in no case be prejudicial to their health. This shall apply in particular to the dormitories of prisoners of war, as regards both total surface and minimum cubic space, and the general installations, bedding, and blankets. Food and meal times are, of course, an important consideration for all prisoners. This is addressed in Article 26. The basic daily food rations shall be sufficient in quantity, quality, and variety to keep prisoners of war in good health and to prevent loss of weight or the development of nutritional deficiencies. Account shall also be taken of the habitual diet of the prisoners. The detaining power shall supply prisoners of war who work with such with such additional rations as are necessary for the labor on which they are employed. Sufficient drinking water shall be supplied to prisoners of war, and the use of tobacco shall be permitted. Prisoners of war shall, as far as possible, be associated with the preparation of their meals. They may be employed for that purpose in the kitchens. Furthermore, they shall be given the means of preparing themselves the additional food in their possession. Collective disciplinary measures affecting food are prohibited. In terms of hygiene, the detaining power shall be bound to take all sanitary measures necessary to ensure the cleanliness and healthfulness of camps and to prevent epidemics. Baths and showers and sufficient water and soap must be provided. Article 30 provides that every camp shall have an adequate infirmary where prisoners of war may have the attention they require, as well as appropriate diet. Isolation wards shall, if necessary, be set aside for cases of contagious or mental disease. Medical inspections of prisoners of war shall be held at least once a month. They shall include the checking and the recording of the weight of each prisoner. Their purpose shall be, in particular, to supervise the general state of health, nutrition, and cleanliness of prisoners, and to detect contagious diseases, especially tuberculosis, malaria, and sexually transmitted diseases. It is important to briefly address the particular case of medical personnel and chaplains and other religious professionals. They are not, of course, combatants. They're dealt with in Article 33. Members of the medical personnel and chaplains, while retained by the detaining power with a view to assisting prisoners of war, shall not be considered as prisoners of war. They shall, however, receive as a minimum the benefits and protection of the Convention and shall also be granted all facilities necessary to carry out their activities. I hope you'll understand I can't go through every article of the Convention, but I thought it would be useful to outline just a few later topics that the Convention covers. So, for example, Chapter 5 of Section 2 deals with religious, intellectual, and physical activities. Chapter 6 of Section 2 deals with discipline, and Article 39 in that chapter states that every prisoner of war camp shall be put under the immediate authority of a responsible commissioned officer belonging to the regular armed forces of the detaining power. This officer shall have in his possession a copy of the Convention. He shall ensure that its provisions are known to the camp staff and the guard, and shall be responsible, under the direction of his government for its application. Prisoners of war, with the exception of officers, must salute and show to all officers of the detaining power the marks of respect provided for in the regulations applying in their own forces. The wearing of badges of rank and nationality, as well as decorations, shall be permitted. Article 41 states that in every camp, the texts of the convention shall be posted in the prisoner's own language at places where all may read them. In addition, copies can be supplied to prisoners on request. In addition, copies shall be supplied to prisoners on request. Article 44 deals with the treatment of officers. Officers and prisoners of equivalent status shall be treated with the regard due to their rank and age. In order to ensure service in officers' camps, other ranks of the same armed forces who, as far as possible, speak the same language, shall be assigned in sufficient numbers, account being taken of the rank of officers and prisoners of equivalent status. Such orderlies shall not be required to perform any other work. Section 3 of the Convention makes provision for the right of the detaining power to use prisoners of war for work. The detaining power may utilize the labor of prisoners of war who are physically fit, taking into account their age, sex, rank, and physical aptitude, and with a view particularly to maintaining them in a good state of physical and mental health. Non-commissioned officers who are prisoners of war shall only be required to do supervisory work. Officers may in no circumstances be compelled to work. Article 50 sets out the classes of work that prisoners of war may be compelled to undertake, but all types of work that have a military character or purpose are excluded from the types of permissible work. And we come back to that briefly when we look at some case law from the ICTY. Section 6 is entitled Relations Between Prisoners of War and the Authorities. Chapter 3 of Section 6 deals with penal and disciplinary sanctions. Article 82 states that a prisoner of war shall be subject to the laws, regulations, and orders in force in the armed forces of the detaining power. The detaining power shall be justified in taking judicial or disciplinary measures in respect of any offence committed by a prisoner of war against such laws, regulations, or orders. Article 84 goes on to say that a prisoner of war shall be tried only by a military court, unless the existing laws of the detaining power expressly permit the civil courts to try a member of the armed forces of the detaining power in respect of the particular offence alleged to have been committed by the prisoner of war. In no circumstances whatever shall a prisoner of war be tried by a court of any kind which does not offer the essential guarantees of independence and impartiality as generally recognized, and, in particular, the procedure of which does not afford the accused the rights and means of defense. Prisoners of war may not be sentenced by the military authorities and courts of the detaining power to any penalties except those provided for in respect of members of the armed forces of this power who have committed the same acts. Collective punishment for individual acts, corporal punishment, imprisonment in premises without daylight, and, in general, any form of torture or cruelty are forbidden. If the death penalty is pronounced on a prisoner of war, the sentence shall not be executed before the expiration of a period of at least 6 months from the date when the protecting power receives a detailed communication from the detaining power. Part 4 is important. It covers the termination of captivity. Article 109 states that parties to the conflict are bound to send back to their own country, regardless of number or rank, seriously wounded and seriously sick prisoners of war, after having cared for them until they are fit to travel. Throughout the duration of hostilities, parties to the conflict shall endeavour to make arrangements for the accommodation in neutral countries of the sick and wounded prisoners of war. Certain categories of prisoners of war shall be repatriated directly. There are three: those who are incurably wounded and sick, whose mental or physical fitness seems to have been gravely diminished. The wounded and sick who, according to medical opinion, are not likely to recover within 1 year, whose conditions require treatment, and whose mental or physical fitness seems to have been gravely diminished. And thirdly, wounded and sick who have recovered, but whose mental or physical fitness seems to have gravely and permanently diminished. Article 118 provides that prisoners of war shall be released and repatriated without delay after the cessation of active hostilities. The costs of repatriation of prisoners of war shall, in all cases, be equitably apportioned between the detaining power and the power on which the prisoners depend. Articles 129 and 130 set out provisions for penal sanctions for grave breaches of the Convention. The high contracting parties undertake to enact any legislation necessary to provide effective penal sanctions for persons committing or ordering to be committed any of the grave breaches of the Convention defined in the following article. Each high contracting party shall be under the obligation to search for persons alleged to have committed or to have ordered to be committed such grave breaches, and shall bring such persons, regardless of their nationality, before its own courts. It may also, if it prefers, and in accordance with the provisions of its own legislation, hand such persons over for trial to another high contracting party. So the following article says this, Article 130. Grave breaches shall be those involving any of the following acts if committed against persons or property protected by the Convention: willful killing, torture or inhumane treatment, including biological experiments, willfully causing great suffering or serious injury to body or health, compelling a prisoner of war to serve in the forces of the hostile power, or willfully depriving a prisoner of war of the rights of fair and regular trial prescribed in the Convention. So, having looked at the provisions or some of the provisions of the Convention, I come on to provisions of the Criminal Code of Ukraine that deal with prisoners of war. On the one hand, Article 430 criminalizes the act of voluntarily rendering oneself prisoner of war due to cowardice. This shall be punishable by imprisonment for a term of 7 to 10 years. Article 431 defines criminal actions of a prisoner of war and establishes the penalties for such criminal actions. These include voluntarily participating voluntary participation of a prisoner of war in any works of military importance or any other activities that may be detrimental to Ukraine or its allies, where it involves no elements of high treason. Violence or cruelty of a senior prisoner of war in respect to another prisoner of war. Actions taken by a prisoner of war to the detriment of other prisoners of war for selfish motives or to win indulgent treatment of the enemy. Article 434 is perhaps of greatest relevance. It's entitled Ill Treatment of Prisoners of War. Repeated ill treatment of prisoners of war or any such treatment combined with exceptional cruelty or committed in respect of sick or wounded persons, and also negligent performance of duty in respect of sick or wounded persons by persons required to provide medical treatment and care to them where it involved no elements of a more grave criminal offence, shall be punishable by imprisonment for a term up to 3 years. Where a more grave breach of the Geneva Convention is involved, the penalties are higher. And here we turn to Article 438. Violation of rules of warfare. Cruel treatment of prisoners of war or any other violations of rules of warfare recognized by international instruments consented to by the Verkhovna Rada of Ukraine, and also giving an order to commit any such actions, shall be punishable by imprisonment for a term of 8 to 12 years. The same acts, accompanied with murder, shall be punishable by imprisonment for a term of 10 to 15 years or life imprisonment. I have to admit that it's not clear to me what the difference is between ill treatment of prisoners of war combined with exceptional cruelty, as provided for under Article 434, and cruel treatment of prisoners of war or any other violations of the rules of war recognized by international instruments under Article 438. The difference is not clear to me at all, but perhaps in the original Ukrainian, the distinction is clearer. And then finally, in the last couple of minutes, I want to discuss a few cases from the case law of the International Criminal Tribunal for the former Yugoslavia, the ICTY, dealing with the treatment of prisoners of war. It may be useful in the future to know about these cases that were decided by an international tribunal. There is no directly relevant jurisprudence as yet from the International Criminal Court. In the judgment in the case of Perlich et al., Perlich, case number IT0474T, dated 29th of May 2013, it was held that a detaining power may compel prisoners of war, other than officers, to work under certain conditions. We know that, that's provided for in the Convention. But the use of prisoners of war for work on the defensive structures of the detaining power is clearly included among the categories of military labor prohibited under applicable law. The court in Perlich also held that members of the armed forces of a party to the conflict may not be considered prisoners of war under the Geneva Convention when they are placed into detention by their own armed forces. The Perlich judgment also considered the situation of reservists. The judges found that a reservist becomes a member of the armed forces within the meaning of international humanitarian law once he has been mobilized and has taken up active duty. It is only then that a member of the reserves acquires the status of combatant and becomes a prisoner of war if he falls into the hands of the opposing party during an international armed conflict. Such a person enjoys the status of combatant from the instant he is mobilized and enters into active duty until such time as he is permanently demobilized. Outside this temporal framework, a member of the reserves is a civilian and cannot in any event be considered a prisoner of war if detained by the opposing party during a conflict. In the ICTY judgment in the case of Merksic et al., and that's case number IT 9513/1T, dated 27 September 2007. It was held that Merksic, a colonel in the Yugoslav People's Army, knew that both violence and cruel treatment was occurring to Croat prisoners of war, despite the existing security arrangements he had ordered. And he was well aware of the animosity to the prisoners of the ultimate perpetrators of the violence. He was aware of the perpetrators' propensity to extreme violence against prisoners of war, yet he took no action to prevent the continuance of the offences of cruel treatment that had been occurring. He had readily available to him more than adequate numbers of officers to ensure that the incidents of mistreatment that had occurred were not repeated. His omission or failure to act constituted aiding and abetting the acts of torture and cruel treatment. So I will end there. There's a great deal more that could be said about the status of prisoners of war in international armed conflicts, and I'm afraid I have really only scratched the surface of this fascinating subject. But I hope you found this presentation of some use nevertheless, and I thank you for your kind attention.